morning, everybody. I am calling the case of Ha et al. Versus Nationwide General Insurance. I'd like to welcome Mr. Feldman and Mr. Kirby to these historic virtual oral arguments. These are the first for the Supreme Court's 200th year anniversary in history, and welcome those of you who are viewing and live stream. Mr. Feldman.
Madam Chief Justice, Associate Justices, may it please the Court, I'm Stephen Feldman. Leslie Packer and I represent Nationwide. I wish to reserve 6 minutes of my time for rebuttal.
You may.
This is a statutory interpretation case. Under Section 584115, the section that the parties in the trial court assumed applies to the plaintiff's policy, an insurer can cancel a policy at any time for 10 specified reasons. In the same statute, the General Assembly provided that an insurer can cancel a policy for any reason within a policy's first 60 days. The issue in this case is whether the General Assembly intended for the same notice requirements to apply to all cancellations governed by Article 41, or whether, as the plaintiffs suggest, the General Assembly intended two entirely different notice regimes and did so entirely through an undefined word, the word furnishing. That is the plaintiff's entire case here, and it's a theory that clashes with and does not align with this court's teachings on statutory interpretation. Those teachings emphasize the legislative intent as the lodestar of the court's analysis, and that structure and context are the key to reading a statute's plain language and ordinary meaning. For those reasons, the robust proof of mailing that Nationwide provided to the trial court, as the trial court concluded, satisfied Nationwide's notice obligations. Proof of mailing is sufficient.
Yes, sir. Excuse me.
Yes, Justice Newby.
The Rate Bureau suggests that the statute that is being discussed is actually not applicable to the current facts or the facts of the current case. Should the Supreme Court of North Carolina make a pronouncement about statutory interpretation for statutes that don't even apply? Or put another way, are we bound by a legal stipulation when the legal stipulation is wrong?
Thank you, Justice Newby. To answer that, maybe the end of the question first, this court is not bound by stipulations made by the parties and with the trial court about the governing framework, the statute that governs here. I say that with a full concession and acknowledgement of the record that this case was tried under the theory that Article 41 applies. We know, though, from cases like Quick that the Rate Bureau cited, that stipulations of law do not bind the court. And that rule, of course, makes sense. This court is not ever required to announce law that it believes is mistaken. It's the highest court in the land. Even aside from a case like Quick, the court's other decisions make clear that when it comes to de novo review of a statute, that de novo review encompasses all parts of the statute. Indeed, even in the briefing in this case, both parties, I believe, cite to 5841.5, the purpose section, the legislative intent section. 5841.10 is the section in between that purpose section and the notice section that's the subject of this dispute. And under the plain language of 5841.10, this policy written under Article 36 plainly is exempted. So to your question, Justice Newby, no, the court is not required to announce law that it believes is mistaken. And in this case, the court has the flexibility to rule on that basis. And obviously, even if Article 41 did apply, Nationwide's argument is the same either way, that under Chapter 58, proof of mailing is sufficient proof of notice.
Well, Mr. Feldman,
The Rate Bureau suggests the remedy of making the legal statement about what law is properly applied but then remand into the Court of Appeals to apply that law. Do you agree with that?
Justice Newby, if the court were to conclude that Article 36 either, or strike that, if the court were to conclude that Article 41 does not apply because this policy is written under Article 36, then whether the court reverses on just the de novo review or whether the court were to remand for an initial determination before the Court of Appeals, either of those would be certainly acceptable to Nationwide. And we leave in the court's sound discretion on how to handle that.
Is there a reason if it were to be remanded for it not to go to the trial court?
Justice Hudson, that's an excellent question. And candidly, I do not know the answer, though I can say, if this is where your question is going, that the trial court, which again ruled for Nationwide, was not presented that particular scope question. So if the question is, would the Court of Appeals be ruling on essentially a blank slate without record from the trial court, the answer would be yes to that.
Okay, it's an unusual presentation of the situation. I'm sure you would agree with that. And
I would agree with that, Justice Hudson, very much.
So I guess my question is, what under the circumstances would be the most sound thing for us to do if we were to agree that it appears the parties didn't raise a critical issue?
Again, with Justice Hudson, to sort of harmonize over my answer I'm giving to you with my answer to Justice Newby a moment ago, that Nationwide ultimately defers to the court's discretion. This is a situation where the parties did brief the issue in before this court, even if not in the same sort of robust fashion perhaps that you normally see, because as Justice Hudson, you put it, the unusual nature of these proceedings. But ultimately the interpretive issue is quite crisp and straightforward. And for that reason, I think the court could and should have a lot of comfort ruling just on that. I don't think there's a dispute that this policy was written under Article 36, which means it was a rate bureau form. I don't think that's a factual issue. And that being the case, the plain language of 584110 exempts it. So even if, Justice Hudson, this case were remanded to the trial court, I think it's that same straightforward interpretive question that the trial court would confront.
Mr. Feldman, is there a statute that does apply to the cancellation provisions of this particular policy, whether under Article 36 or under some form of insurance regulation?
Right. That is a question, certainly, when I arrived at this case that I certainly studied a lot, because all of us would have to imagine that there are cancellation notice requirements. We all have insurance at some point, and so something's got to govern. Here's the legislative regime as it stands, is that under 583655, the Rate Bureau presents policies to the commissioner. And now, dating back for a long, long time, as shown in our brief, there has been the only policies that can be written in North Carolina on homeowners have a mandatory cancellation notice period like that in this case. It is not expressly written in this in the statute. Justice Ervin, I'm sorry, do you have a question?
Is it your contention then that the notice requirement is whatever the commissioner is willing to approve based on a filing made by the Rate Bureau?
On this record, on these facts, I think the answer is yes, that the cancellation period, notice period, is the notice period that.
But I thought Justice Davis's question was, is there a statute that governs this issue?
Right. So to that, just to address that.
You haven't pointed one out, so therefore it would appear to me that the gist of your argument is no, there's not a statute, and B, the extent of the protections is whatever the regulatory authority was willing to allow or require.
I think the latter part, Your Honor, is generally correct, with the sort of background that for certain policies like a fire loss policy, there's a minimum of 5-day notice requirement by statute. Obviously, the notice provided here of 15, and then the policy period today, or in the policy, which is 10, is longer than that. But Justice Ervin, you're right, there is not a flat
I mean, your answer, if we're talking solely about homeowners policy,
Correct.
I mean, let's put aside fire policies or any automobile liability policies, which are statutory, anything like that. Is it your understanding that there is no statutory notice requirement? Any notice requirement that exists is whatever the commissioner ultimately deems in his regulatory exercise his regulatory authority to be acceptable?
I think the General Assembly, I think the answer is sort of roughly yes, with the answer also being shaded by the General Assembly, has not obviously seen fit to enact a notice period beyond the long-standing notice period that it's been in effect. So to the point of legislative intent, I think that can be read back to the General Assembly. But is there a statute that says X days of notice for every homeowner's policy? No.
Mr. Feldman, just so we're clear, I mean, it's really a yes/no issue. If we were to agree with this argument and remand it, on remand, would the lower court be applying anything other than the cancellation provision in this policy?
Correct. They would be applying the cancellation provision in the policy, the 10-day notice period, which again, nationwide more than compliant with, providing 15 days. Correct.
Nothing else would apply other than this policy provision, correct?
I don't know what other defenses the plaintiffs might have here, arguments.
There's no other statute or regulation. It would just be a matter of the policy, correct?
Correct. The policy would govern, yes.
Thank you.
So just to follow, if I may follow up on that question, I would like to know what your view is on General Statute Section 58-36-45, and 36 is the part of the article that applies to homeowners insurance. And there it says, it doesn't say how notice shall be given, but it says whenever an insurer changes the coverage other than at the request of the insured or changes the premium rate, it shall give the insured written notice of such coverage change or premium rate change at least 15 days in advance of the effective date of such change or charges, with a copy of such notice to the agent. So doesn't that apply to homeowners insurance?
Candidly, Your Honor, whether or not there's a distinction between coverage change and cancellation, I honestly can't answer that, and I apologize for it. But I can say, as a practical matter, Justice Earls, that seems exactly right. That the coverage change is you're going from coverage had and then 15 days later not having it. So perhaps yes, and it certainly goes to the spirit, Your Honor. I welcome, obviously, any other questions on this, on the scope issue and the unusual situation presented. But in the absence of that, I will return to 5841-15, the statute the parties in the court agreed at the time applied. On that point, again, the plaintiff's case rests on the single word furnishing. The notion that by using this lone word, the General Assembly intended to have a different notice regime for policies canceled in the first 60 days of the policy. That's mistaken for at least 4 different reasons. One of them is just the straightforward structure of Section 5841-15. Subsection A lists the 10 reasons for cancellation at any time. Subsection B says, here's how notice is given. Subsection C says, if the policy is canceled in the first 60 days, the policy can be canceled for, quote, any reason, end quote. Obviously, any reason referring to the first 10 reasons listed in A or any other reason. And then says, as long as notice is furnished to the insured 15 days ahead of the cancellation. Again, this court's decisions time and again refer to reading the words in a statute by their ordinary meaning in the context and structure of the statute, it is clearly the intent of the legislature, or to the extent it was not their intent, they certainly failed to say so, for the notice to be somehow changed impliedly on this word, furnishing.
Well, if proof of mailing and furnishing would be identical, why wouldn't the legislature just go ahead and repeat proof of mailing in C as it did in B?
Right. Well, that's the good question, Justice Morgan, is why didn't they just repeat it? And I think one straight answer is, the legislature is not. Well, let me take a step back. Maybe the first line answer is nothing in this court's decisions require that level of repetition. And obviously nothing in this court's, I think, jurisprudence requires that level of precision or perfection if the language can be understood from the structure and the context. But let me give three other reasons separate and apart from just the sort of language textual reasons.
Well, before you do that, the first sentence in subsection C is, this section does not apply to any insurance policy that's been in effect for less than 60 days, and goes on from there.
Yes, Your Honor, absolutely. And so the fair question that Your Honor is asking, we might have all asked ourselves, well, what did the General Assembly mean by those words?
Doesn't it mean on its face that the rest of the section doesn't have anything to do with policies that are being canceled for reasons, within the 60-day period that the company's got the ability to cancel it because they don't like the trees growing in the yard?
Well, again, without getting into sort of what sort of whether there might be any limits to any reasons applied by other areas of law, subsection C read in its entirety taken together means that the reasons listed in A are not the only reasons, as Your Honor points out, that a policy can be canceled within the first 60 days. And even the plaintiffs, I point out, I believe on page 23 of their brief, doesn't suggest that somehow that language, this section, does not apply to the entire section. And the second sentence of C, again, taking this court's admonitions to read a statute in the whole, says that policy may be canceled for any reason by furnishing to the insured at least 15 days prior written notice and the reasons for the cancellation. Those two sentences harmonized together sort of naturally without any ambiguity are saying first 60 days you're not limited by A. That's the thrust of it.
It says more than that, doesn't it? It says that the rest of the section doesn't apply to cancellations within the first 60 days.
Well, what it's saying is obviously there should be some form of notice given, but in context, when it says this section does not apply, it's referring to those first 10 reasons, not applying it again. That is the same interpretation.
The section in its entirety is everything in 58-41-15, isn't it?
Well, again, the words "this section" or that whole sentence in C, taken together with the second sentence, shows the legislative intent that the first 10 reasons in A don't apply within the first, or not the only reasons rather that apply within the first 60 days. And again, even the plaintiffs here don't read that statute anything beyond it. I think that confirms the natural reading that we agree on that much. But I understand Your Honor's fair question of, that is a broad way they phrased it. And again, it might come back to the point raised with Justice Morgan that this is not what level of precision is required. And I think the answer is the degree of precision depends on how clear whether the natural reading and structure and context of the statute make the intent clear. And here it is clear.
When you say it's clear, if we're trying to glean statutory construction, as you will identify this case to concern, when we look at different language being employed by the legislature between subsection B and subsection C, why would not the court look at the differentiation in those terms, proof of mailing and furnishing, as somehow meaning, therefore, the legislative intent was that there should be a different standard for each of them?
Justice Morgan, three answers to that question. And to be sure, the selection of words is a key part of statutory interpretation. I acknowledge that completely. But three answers here. One, if you look at the legislative intent section of this statute, 5841(5)(b), the General Assembly said expressly that it desires a uniform requirement for notice and for providing cancellation. The plaintiffs are expressly arguing for the very opposite, that for cancellations, it's not uniform. So to the extent of, well, why did the General Assembly choose a different word? Seems unusual that in choosing a different word that clashes with the uniform requirement and that's undefined, not only in the statute, but in North Carolina case law, seems that it's a weak use of that particular interpretive canon. Second is, the purposes the plaintiffs themselves have acknowledged. The purpose of this 60-day underwriting period is to provide insurers with the ability to issue insurance pretty rapidly, which is beneficial for North Carolinians seeking insurance, while also giving insurers the ability to do a full underwriting review. Given that cancellation for reasons in A, these 10 limited reasons, are harder on insurers, and cancellation under C is more liberal, it's certainly counterintuitive at best that cancellations under C would somehow have to be more restrictive to insurers. Those don't harmonize at all. And then three, Justice Morgan, if you look at the rationale provided by the plaintiffs in their brief here, and sort of the key reason you can find on pages 10 and 11 of the decision of the Court of Appeals, the thrust of it is that, well, the folks who have their policy canceled under a reason in A, they're on notice. They're wrongdoers. They should know that their policy is being canceled. That rationale does not hold up when you actually go through the reasons, the 10 reasons listed in A. To give examples, A2 involves a material misrepresentation or non-disclosure of a material fact by an insured. This case presents that very situation, where in the second phone call with Nationwide, Mr. Tron said, do you have in response to the question of whether there was a trampoline, answer no. No one's here saying he's a wrongdoer. No one's saying anything one way or another, but that affected Nationwide's underwriting view. Look at other sections within A. A7, loss of reinsurance. That has nothing to do with any action by an insured. Number 9, a determination by the commissioner that the continuation of the policy would place the insurer in violation of the laws of the state. That has nothing to do with the action of an insured. Look at 3, increased hazard or material change in the risk assumed that couldn't have been contemplated. That doesn't involve an act by the insured. Or even the first, non-payment of a premium. Probably all of us, and certainly a lot of North Carolinians, end up having situations where some bill doesn't get paid for some reason that it's not purposeful, whether it's the bill pay not going right, whether it's overlooking the bill when it arrives in the mail, whether it's just being a little bit late, whether there's not enough money in the checking account, whatever it is, no one's calling that a wrongdoer. With these points being said, I will reserve the remainder of my time for rebuttal and thank you, the court, for its consideration.
Thank you, Mr. Feldman. Mr. Kirby.
If it please the Chief Justice and Associate Justices of the North Carolina Supreme Court, my name is John Kirby and I represent the plaintiffs' appellees in this case. We are asking this court to affirm the decision of the majority panel of the Court of Appeals below, which ruled in favor of my clients in determining that they were entitled to coverage under their homeowners policy for this loss that they sustained. As I'm sure your honors are aware from the briefs, the facts underlying this case are fairly straightforward. In July 2015, while my clients were at a church service, they received a call indicating that their house was on fire. The house was a total loss along with the contents. They basically lost everything they had. As if that loss weren't enough, losing things like family photographs you can't get back. They then called Nationwide only to learn that the house was not covered. Based on the findings of the trial court below, my clients were unaware that Nationwide had canceled or attempted to cancel the policy. So as they were away at their church service on a Friday evening, they felt safe and secure that they had coverage. The case went to trial before the trial judge as a bench trial, and the pertinent findings for this appeal are that these issues were hotly contested. Both sides presented witnesses. My clients testified, their family testified, Nationwide employees testified. We presented an expert witness on postal regulations, and the pertinent findings relevant to this appeal. The trial court found that Nationwide did mail or send the notice of cancellation, but also the trial court found, sitting as the finder of fact in finding number 20, that the plaintiffs did not receive the cancellation letter. So it was in that posture the case went to the North Carolina Court of Appeals. The trial court had determined that Nationwide complied with its both statutory and policy obligation. That is the theories that were presented to the trial court. The trial court ruled on both of those, in other words, both the statute and the policy. It's, of course, in that posture that we get to the North Carolina Court of Appeals. And in that case, the majority of the Court of Appeals determined in the 2-to-1 decision that when the cancellation notice was not received by my clients, that Nationwide did not comply with its statutory obligation to cancel the policy. Therefore, the policy was still in effect.
Mr. Kirby, do you concede that there has been a misapprehension of law as to the applicability of Article 41?
Yes, Justice Davis, I'm glad you raised that question. So just to sort of put this in context and to take a tiny step back. So when this case was filed, even in our complaint, we made reference to this particular statute we're talking about here. Nationwide filed an answer and counterclaim. They cited to the exact same statute. The case was tried to the trial court under this statute. Both parties agreed in arguments briefs, both to the trial court and to the Court of Appeals, that this is the statute that governs cancellation. In its brief to this court, in a footnote, not in the main body of the argument.
Well, let me just stop you there. Before we get to the question of what we should do about it, do you agree that Article 41 in reality does not apply on these facts?
To answer that question, Your Honor, I say no. And to answer that requires us to go into this more complex analysis of exactly what Article 41 says. This issue has not been thoroughly briefed before this court, but basically in a nutshell, the statute they're relying on is 58-41-10. This is the statute that talks about the scope of Article 41. If you look at the very first sentence of that, it talks about the policies to which it applies. It then makes reference to 2 other statutes and specifically subsections. If you look at those statutes, it then makes reference specifically to fire policies. So on its face, clearly this is covered by the scope. You then come down to the second sentence, which seems to be the one that the amicus brief is relying on. The second sentence says this article does not apply to the following policies, and it lists several types of policies, one of which are policies, according to the statute they're citing, it says policies written under articles, and then it says 36. So our position is this policy here is not a policy written under Article 36.
And why not?
Yes, sir. I'm sorry.
Why is it not a policy written under Article 36? It's labeled the homeowner's policy, isn't it?
Well, the policy is a homeowner's policy. I'm not aware that Article 36 pertains to homeowners' policies per se. There are specific provisions in Article 36 that pertain to homeowners' policies. As just an example, there is a statute within Article 36 that addresses homeowners' policies issued on the coast that has certain exclusions for wind and hail. This is 58-36-42. So within Article 36, there are some specific statutes. This one in particular is 58-36-42. There are particular statutes that pertain to homeowners' policies, but as a whole, I contend a homeowner's policy is not, quote unquote, written under Article 36. Some homeowners' policies may be subject to certain provisions of Article 36, but that doesn't mean that all homeowners' policies are written under Article 36. I would also note that there are other statutes that are much more applicable to homeowners' policies, and we're sort of jumping ahead in the argument, but there's a statute that directly pertains to homeowners policies. It's and these, by the way, are often called fire policies, but in statute, in Article 44, this is statute 58-44-16. In other words, this is not within Article 36. This is Article 44, which is not excluded from the scope of Article 41. There's
Well, what do you make of the language in Article in GS 48-4110A that says that this article does not apply to, quote, or insurance written for residential risk? Excuse me, I've lost my place here, but there's a reference to residential risk that
yes, sir.
is applicable to property with less than 4 houses.
Well, yes, sir. So I believe the portion that you are referring to is again the second sentence. It says this article does not apply to, and then it lists various things. And it says insurance written for residential risks in connection with insurance written under Article 36 of this chapter. So again, this exclusion in Article 41 is limited to certain types of policies. It doesn't say anywhere all homeowners policies, all fire policies, all residential policies are excluded from the coverage under this. And again, yes, sir.
I was going to ask, though, if that's the case, what do you find about, what do you make of the language in Article 41 that refers to the applicability of that article to commercial risk?
Well, so there is some language, and I think you may be referring to the previous statute that talks about the purpose and intent and effect of the statute. There are some sentences and lines from that statute that reference commercial insurance, but it doesn't indicate that the article in its entirety is limited to commercial policies. And there's a lot of language within Article 41 that is very broadly written that would apply to all types of insurance. So yes, the word commercial appears, but in no location is Article 41 limited to commercial policies.
Is it your contention that GS 58-41-15 applies to all insurance policies issued in the state except the ones that are statutorily prescribed, like automobile policy?
Well, I think, again, if you're looking at the issue of the scope, I do think you have to go back to 58-41-10, which talks about the first sentence says what is included in the scope, and then the second sentence says what's excluded. And to parse through that and go through every article of Chapter 58 would be terribly complicated. So,
and I'm certainly not going to volunteer to do it.
Right, but basically, if we do go into this rabbit hole of asking whether or not this policy is subject to Article 41, I submit that it is not. And there's reasons I've given for that. Again, I would emphasize Article 44 has a much more specific provision on homeowners policies. But the other point I would make, and I do appreciate Justice Davis's question, but this is the real fundamental problem with getting to this court and trying to raise an issue for the first time on appeal, an issue that wasn't raised below, wasn't argued, it wasn't even tried on this theory. So I think it was Justice Hudson had a question about, well, what would we do even if we thought that there's some validity to this? And frankly, I don't know how you can unwind this clock. I don't know how you can get the toothpaste back into the tube at this point, because the whole case was tried under this theory. Witnesses were presented, expert witnesses. It's been argued and briefed. In our brief, we just briefly cite to some of the doctrines that we contend would apply here. There's doctrines of judicial estoppel. There's, of course, the notion that appeal to this court is limited to what's raised in the dissent.
Mr. Kirby, is it your position that we're bound by a stipulation of law by the parties or the lower courts?
I wouldn't go that far, but I would say that if the parties have tried the case under a certain theory, they cannot later on appeal completely 100% disavow that theory and take a contrary position on appeal. There's, of course, lots of cases from this court indicating that you can't, they use the language swap horses in midstream or swap horses on appeal. This is largely a judicial doctrine. But it does raise issues of fundamental fairness. How is it fair to us after we've tried the case, presented evidence, hired an expert under one set of theories, to then go back and basically do a bait and switch and completely change the theory of the case. But no, I mean, certainly this court and any court can determine what statutes apply. I would also note this is not an issue like subject matter jurisdiction. This is not something that can't be waived. I would contend a court can certainly say this case was tried on this theory. The parties agreed to this. It was taken to the Court of Appeals on this theory. Therefore, that's the only issue that's before us. And opening the other can of worms raises a lot more problems than it solves.
But aren't we, if we are interpreting the statute, isn't part of the task of interpreting the statute, and indeed part of the task of carrying out the will of the legislature, to determine whether or not, in fact, the statute applies?
My response to that would be that if the applicability of this statute was not raised below, that as a general matter, that issue is not raised on appeal. What is
well, let me ask you about that as well, because you mentioned judicial estoppel, and as I read Whitaker Partnership versus Biosignia, which is the case you cite on this question of judicial estoppel, it explicitly says that judicial estoppel does not apply to inconsistent legal positions, and that, you know, I think that under the fundamental notion that the court, particularly when we're interpreting a statute, we have a duty of saying whether or not it applies, even if the parties assumed without briefing that it applies.
Sure. I understand that question. And just one distinction I would note is in this case, it's not just an inconsistent legal argument that Nationwide is injecting into this case. It's really a complete reversal to argue below and agree that a given statute applies, and then on appeal to do a 180-degree turn is not just arguing an inconsistent position. It's an outright rejection of the position that they previously took. And again, it would raise issues of fundamental fairness. If this court were hypothetically to affirm the decision of the Court of Appeals, let's say hypothetically you affirm that decision per curiam, that decision would have binding effect only as to the issues that were raised in that case. That's true of any appeal. So if in a future case, if Nationwide or Farm Bureau wants to raise the issue of whether Article 41 applies, it can do so. But in terms of this appeal, I would contend that the appropriate judicial doctrines indicate that Nationwide should not be able to change its position, and the case should be decided on the theory that was.
Mr. Kirby, you say it's impossible to unring the bell, but I'm not sure I quite understand that answer. I mean, if Nationwide had argued that this was the incorrect statute and the lower courts had disagreed with them and the issue had been properly preserved, we would simply remand it to the Court of Appeals with further instructions to remand it to the trial court to apply the applicable law. So, I mean, why is this any different?
I do appreciate the question. As just one answer to that question, if at the outset Nationwide had said, no, this statute doesn't apply, this statute does not govern the cancellation of a homeowner's policy, then at that point, we would have, and of course the trial court would have had the same obligation to see whether any other statutes apply here. And I think several of the justices have asked the question here, is there any statute that applies here? And with all respect to Mr. Feldman, he was asked the question several times. I don't know that he hit this on the head, but if Nationwide had said, no, this Article 41 does not apply, there is at least one other statute that would have applied. We could have raised that, argued that. That could have been explored through litigation. That particular statute is the one I mentioned before. It's 58-44-16. So if Article 41 doesn't apply, there is in fact another statute that would apply. But this.
Why can't you litigate that on remand?
The only issue that I would raise is that other statute uses different language, and so if we were to go back as just an example. There was lots of evidence and testimony presented in this case about Nationwide's, about their mailing procedures, about postal regulations, how things are mailed. If we were to go back now on remand, we'd have to go all the way back to the trial court. And it's, being again, for example, that we have an expert's deposition in the can on one set of theories. I'm not saying it would be impossible to unring the bell or to put the toothpaste back, but at this point, it would be extremely difficult to go back, apply a different statute, which uses slightly different language.
Well, while there has been the aspect of the stipulation, as you will raise, is somewhat reminiscent of parties stipulating that a court has jurisdiction when it may not have jurisdiction, would it not be then the same type of rationale that if the law does not apply that was stipulated to in this case, and this court would find otherwise, that we would not be bound by that, and instead it would be more prudent to send it back for the right application of the law?
Well, I do appreciate that question, Justice Morgan. Our position on that would be that the most prudent thing to do would be to follow several precedent from this court, which holds that parties are bound by their by the positions they took below. I do understand the arguments and some of the statements that have been made here. As I read the Whitaker case, which we talked about some, and I think I cited in my brief, my understanding is the doctrine of judicial estoppel, and it may be different for other doctrines like men to hold, does apply to legal arguments that a person makes, meaning that when a party makes a legal argument, that is binding in them on that appeal. And in essence, what Nationwide is trying to do is to change its argument. But to answer your question, our position will be the most prudent thing to do is to follow the precedent of this court, which has stated, for example, principles such as the scope of appeal here is limited to what is raised in the dissent. The dissent is not raising this issue. I would argue the most prudent thing to do is to follow all that precedent, decide this case as it was argued and as it was decided by the Court of Appeals, and that would fully preserve in any future cases whether Article 41 applies here. If that were not done, then yes, I think the remedy would be, I think you'd have to send it all the way back for more some sort of further proceedings all the way back to the trial level, which again is the reason that we would argue that's not the appropriate way to go. So I'm more than happy to address the scope of Article 41. Of course, that's not the majority of what's in our brief and what the parties have argued and what Mr. Feldman has argued. What we've argued here and what the Court of Appeals argued and what's in our briefs, of course, is the whole issue of Article 41 and the cancellation statute that we've been talking about here, and it was raised before the trial judge. And of course, the issue there is under subsection C, whether or not Nationwide furnished notice of the cancellation to my clients. The trial court found this finding is not disturbed on appeal, is not challenged on appeal, is that my clients did not receive that notice, therefore the notice was not furnished, as a result of which under subsection C, the notice was ineffective. And this is what the majority of the Court of Appeals found. On appeal to this court, I don't even understand Nationwide to take the position that the word furnishing in general means anything other than actual receipt or delivery. The argument that Nationwide is making on appeal to this court is that the language in subsection C, which says that Nationwide had an obligation to furnish my client with notice, the argument they make here is that incorporates in some fashion the language from subsection B, which does have a slightly different language regarding how the notice is to be sent. The problem is that I think we all agree subsection B doesn't apply to subsection C. Subsection B goes along with subsection A. Subsection A talks about reasons that the insurance company can cancel a policy at any time. The first of which, and probably the most common of which, is non-payment of premium. It does list 9 other reasons that an insurance company can cancel the policy at any time. And then subsection B talks about the type of notice that must be given to cancel those policies. That's the way that A and B work together. We then get down to subsection C, which talks about policies canceled during the first 60 days. And that's the one that has the specific language that says they must furnish the notice to the insured. So in this case, of course, that notice was not furnished, and therefore the policy was never effectively canceled. Nationwide, in trying to take the languages from subsection B and apply it down to subsection C, basically turns statutory interpretation on its head. They are essentially rewriting subsection C, trying to put language in there that doesn't exist. If that's what the legislature had intended, there's several ways they could have done that. They could have simply had a subsection F or G that would have addressed the manner in which notice is to be given in all cases. In subsection C, they could have specifically referred back to subsection B. They didn't do any of that. So the Court of Appeals correctly found B and C state different standards of the notice that's required to be given, and the one that's applicable to this case is what's in subsection C. I do want to, yes, sir.
What's your response to, counsel, what's your response to the Court of Appeals dissent position? Defendant actually embraces that position in its brief in this automobile rate office case. What's your reaction to that position, that in looking at the statutory construction of 58-41-15, that it actually favors Nationwide in construing proof of mailing as a clause with furnishing as well?
Okay, so it sounds like you're referring to the case that Nationwide has cited in its brief, in which this court addressed an issue. It was looking at a particular statute that used the word motorcycles. I think you're referring to that case. So there was one statute that specifically referred to motorcycles. It had to do with how rates were affected, how rates could be set for motorcycles. So there's one statute here that's followed by a completely different statute. The first statute did reference motorcycles specifically. The second statute did not. And so the argument was made, well, when the second one did not mention it, the second one does not include or does not cover motorcycles. The main difference in that case that we mentioned in our brief is that in that case, the second statute specifically referred back to the first statute. So there was an extremely specific reference back to the first statute. And that's really what swept in the word motorcycle into the second statute. In this case, looking at the structure of the statute we're talking about here, again, subsection A, B, C, there is also a D, E, and F that address some other issues. But looking at the basic structure here, there's no reason to think that in subsection C, that for some reason the legislature was incorporating by reference without stating it, the language from subsection B. So that's our basic, yes, sir.
Well, I was just going to say, in trying to harmonize, which we're supposed to do, in pari materia, in looking at both proof of mailing as a phrase and furnishing, we did say in that automobile rate office case that the language of a statute must be read not textually, but contextually. And in that aspect, then, why not look at it in such a way that the relation back from subsection C to subsection B would encapsulate the broader view as opposed to the more narrow view?
Okay. Well, just a couple of responses to that. I would first argue that if that's what the legislature intended, if they intended that the language from subsection B would cover C, there are several ways they could have expressly said that. Again, in C, they could have incorporated B. They could have simply had a provision at the very bottom that addressed how notice of cancellation is to be done for every type of policy and every type of cancellation. So the fact that they have the two different subsections, I would argue, is indication that they intended a different standard. This is exactly what the Court of Appeals, the majority of the Court of Appeals opinion found, is that by using different language in different subsections, they meant different things. And we would argue this is consistent with fundamental principles of statutory interpretation, which is that you read, you certainly do read the statute as a whole, but you assume and infer that the legislature understood what it was writing, and it used language in a very deliberate manner. And that in writing it this way, they did intend to have a different type of notification. And again, one other thing I would point out here is that what we're talking about here is, certainly in this case, but in other cases as well, this is someone's homeowner's policy. This is probably for most people, as far as the property they own, the single most important thing that they own. Once they get that policy, and as my clients did here, they had the policy on auto draft, and at all times there was sufficient funds to pay the premium. To your average homeowner, once they get the policy, they put it on auto draft. That's sort of out of their mind. They at that point are assuming, unless and until they hear otherwise, that policy is in place. So that's really why it's so important in a case like this, especially one of these policies that's canceled in the first 60 days for any reason, that the insurance company actually give notice to the insured. This is why this is so important in these types of cancellations in these policies. So I would argue that's further indication as to why it's done this way. One other point I would just note, if there is any ambiguity in the statute, there is also a principle that ambiguities within this type of statute, it's a remedial statute, it's an insurance statute, any ambiguities are to be construed in favor of coverage and in favor of the insured. This principle does exist in the context of homeowners policies, but it also exists, we see this probably more commonly in the context of automobile policies, but the same principle applies. So if there is an ambiguity, that should be construed in favor of broader coverage to the insured, getting that insured more coverage. So that if they think their home is insured, it is, and if the insurance company, And of course, in this case, what Nationwide found, these were fairly minor problems. There was a pool without a fence, a 4-foot fence would have sufficed. Trampoline didn't have a zipper, and the siding, and there was some rotten siding. These were all fairly minor things that could have been very easily addressed. And Mr. Tran, he testified that if he had gotten this notice, he would have addressed those, and he would have kept the policy in place. So this just emphasizes the importance to the insured of getting actual notice, and I would argue that's the statutory intent in this case. I do see I'm down to about 3 or 4 minutes, or a couple of other points I will address. But if any of you have any questions, I'm more than happy to answer those in the time I have left. One of the arguments that Nationwide puts forth in its brief, they basically raise this issue of cost and pragmatism. They take the position that it's too costly to provide homeowners with actual notice of the cancellation. We address this in our brief, but our position is in fact quite the opposite, and we would contend is consistent with what the legislature intended and understood. In this case, Nationwide could have actually provided my clients with notice by email. My client had signed up to receive email notifications, and we have decisions from our courts of appeals going back at least 10 years indicating that notice by email is acceptable. There was also lots of evidence presented about other methods of providing notice. Some testimony was presented about how much it would have cost to send this by certified mail. Certified mail would have cost Nationwide a marginal cost of $2.59. And Nationwide wants to argue that's an extreme cost, that's a big cost. But if you look at that cost in comparison to what's at issue here, again, the insured's property in this case, and this wouldn't be out of line and atypical for many homeowners, was more than $400,000. The annual premium on this policy was just shy of $1,300. So to spend $2.59 to send the notice by certified mail is not some disproportionate cost to put on Nationwide to make sure that the insured gets the notice. And again, there's some argument in Nationwide's brief about, well, what if the homeowner doesn't accept the notice? What if he doesn't sign for the notice? At a bare minimum, though, if they used certified mail, it would show that the letter was delivered to that address. It would give a date. And at a bare minimum, we would know that the slip was at least put in the insured's mailbox. And if they chose to not get that mail, having received the slip in their mailbox, there would be a trail, there'd be a paper trail showing that. And our position is that would constitute furnishing the insured with the requisite notice if the insured chooses to not go pick it up. So the basic point here is there were cost-effective means for Nationwide to provide notice to its insureds. So again, yes.
So I do have a question about some of the other arguments. Oh, if this statute does apply, why would Nationwide's policy and why would it be approved? And I understand your position that approval doesn't necessarily mean they approve every little detail about it, but why would it continue to exist and provide for notice that's different than what this statute provides for in the actual language of the policy?
Okay, so I see I'm down to about a minute. So I think the argument that you're referring to is the argument by Nationwide that the Commissioner of Insurance had approved this policy. So just to respond to that briefly, our first position is, of course, on this record, there is no actual indication in this record that the Commissioner of Insurance approved this policy or this specific language. Secondly, it's important to bear in mind that what Nationwide is relying on here are 9 words, just 9 words in its policy. These are 9 words that pertain to cancellation. This is out of a policy that's 60 pages long. It's important to distinguish. This is not a case where, for example, the Commissioner of Insurance has issued a letter, a notice stating that he or she specifically approves of this provision. And of course, our final position is that even if the Commissioner had done that, that wouldn't be binding on the judicial system. The statute would basically trump what the Commissioner can do. And we did cite to the Glover case from about 70 years ago that basically presented a similar issue.
Thank you, Mr. Kirby.
Yes, sir.
Thank you. Your time
Thank
is
you.
up. Thank you. Mr. Feldman, rebuttal.
Thank you, Your Honor. Thank you, Chief Justice Beasley. If I could address 3 points raised by Mr. Kirby's argument. First, about the court's ability to address the scope of Article 41. Obviously, the questions from the court indicate that the court rightly understands its de novo review to include all aspects of the statute. And this is not an uncommon thing if the court were seeking precedent for this relatively straightforward presumption. There's a case called In re Vogler, 365 North Carolina 389, in which the court turned to the definitions section, much like this case, of an attorney fee provision related to trustees in mortgage foreclosures. Again, the court looked at the statute as a whole, not the precise statute that the Court of Appeals decided. And there's a case called Applewood Properties, 366 North Carolina 518, where the court, in interpreting a statute called the Sedimentation, Pollution, and Control Act, so didn't look at what the Court of Appeals and the parties had provided, but looked to a different part of the statute to determine that the plaintiff lacked standing. So as the court rightly inferred, it need not accept the stipulations of the parties or the court below in discerning what the meaning of the law is in its decisions. Second, on some of the doctrines that Mr. Kirby mentioned, to Justice Earle's point, judicial estoppel does only relate to factual inconsistencies, as does the sort of referred to doctrine that not often applied of mend the hold, where in the case such as the McCaden case decided in 1943, the defendant in that case literally changed his position on what the factual meaning of the contract is. Here, there are no factual issues in this appeal, and the scope of Article 41 is not a factual issue at all. And this falls more into the lines of an alternative legal theory. Whether Article 41 were to apply or not, Nationwide's position has been consistent from the start, and that's proof of mailing is sufficient proof of notice. Finally, Your Honor, or to the court, I would note that in looking at the statute that the trial court did apply, 584115, Justice Morgan, to your question at the end of my initial argument about, well, why would, what do we make of the word furnishing being different? And I provided three different explanations. The purpose of Article 41, providing a uniform requirement for cancellation. Second, the inconsistency in making cancellations more liberal under C, but Mr. Kirby advancing a more restrictive form of notice. And then C, or the third, the 10 reasons listed in A not being reasons, a lot of them, half of them, that have anything to do with wrongdoing. Mr. Kirby had no answers to any of those, and in fact, did not address any of those three reasons. And finally, I might finish again a little to Justice Morgan's question, why wasn't this written a little bit differently? There's this quote I found from Justice Kagan from 2012 in a statutory interpretation case in the US Supreme Court that says, the mere possibility of clearer phrasing cannot defeat the most natural reading of a statute. If we could, we would interpret a great many statutes differently than we do. And I think that quote harmonizes this court's teachings and precedents on statutory interpretation. The legislature need not be crystalline and perfect, but do we understand the most natural meaning? That's the essence of statutory interpretation. For these reasons, Nationwide respectfully requests that the court reverse the decision of the Court of Appeals. Thank you.
Thank you, Mr. Feldman and Mr. Kirby. Madam Clerk, would you please recess us for 15 minutes? Madam Clerk, I think you're muted.
Yes, Chief, I was. My apologies. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.
Thank you.
Thank you.
I think that has us back at 12:05.
Yes.